everyone. Great to see you again virtually. I'm Audrey Coleman. I'm Associate Director and Director of Museum and Archives at the Dole Institute of Politics at the University of Kansas. Thanks so much for joining us for this installment of our Living History Digital series. This will be the last one that we're recording for 2020. It's been a great new series, new experiment for the summer and fall. We'll end with this wonderful interview upcoming and look forward to rebooting the series with new content after the first of the year. So stick with us and stay tuned. Usually on Living History, we're talking with folks who are working in the historical preservation or telling historical stories fields or working with institutions that do those things. Today, we're visiting with someone who is making history and public service in her own right as we speak. And I'm so pleased to have with us Judge Sarah Warner, who is a sitting judge on the Kansas Court of Appeals. Sarah, Judge, thank you so much for being with us today.
Thanks so much for inviting me, Audrey.
Yeah. Let's start by talking a little bit about your experience and your background and tell us what called you to a career in law.
Well, some people know from the get-go that they want to be lawyers or teachers or healthcare workers, and that was not me. In fact, I didn't even know that I wanted to go to law school until the last year of college, but I'm getting ahead of myself. I grew up in Pittsburgh. I went to a small high school there and graduated in a class of 35. But even then, I knew from an early age that I was always interested in the bigger picture. I devoured books. I wanted to learn everything. I wanted to figure out how everything fit together. And so when I went to college at the University of Kansas, I didn't really know what that looked like as a career. I just knew that I liked learning. But because I was interested in so many different things and curious, I put together a diverse background. I collected majors like kids collect baseball cards, and I ended up majoring in math, French, political science, and international studies. And by the time I got to my final year, I had all of this knowledge, but no real path. But I knew that I wanted to put together something that involved both some intellectual rigor and then had a practical side to it. And I was the middle child, so I always had this innate appreciation for fairness, surrounded by brothers. And so I decided that maybe the law was that perfect intersection of interests, right? You have this intellectual challenge of applying an abstract legal principle to very practical facts when people are looking to you to help them sort out their problems. And that was incredibly appealing. And then I should add, there's one final side to the picture, and that is I decided to go to law school, obviously, and then after law school I worked for a justice of the Kansas Supreme Court. And that's such an interesting position because it allows you to work right from the start with someone who is at the pinnacle of his career in this particular instance, to learn how to research, to learn how to write effectively, and then to learn how to think. And it was life-changing. I knew that these particular strengths that I had to look at a case and parse out the law and examine how to explain how the law applies in a particular instance so that people can understand it and can appreciate the process was something that hit home. And so I knew not only that I wanted to be a lawyer, but eventually at some point I wanted to be a judge.
So tell us a little bit about, for those of us who may not be familiar, what is the Court of Appeals here in the state of Kansas, and how does it relate to other court systems in the state and locally?
That's a good question. Not very many people understand the work of our intermediate appellate court. And in fact, not every state has one. 40 out of the 50 states have one, but 10 out of our states just have a trial court and a state Supreme Court, which are the two aspects of the court system I think people are most familiar with. So to start out, Kansas Court of Appeals consists of 14 judges. I am the most recently appointed judge to the court. So I took the bench in July of 2019. And actually right now we have 11 judges because we have 3 vacancies on the court where people have either been appointed and are awaiting Senate confirmation, or we're waiting for someone to be appointed to fill that vacancy. You know, most people, I think, have a general understanding for what happens at the trial court level, or what we call district courts. You know, that's where you go and you file your case and you can argue motions to a judge, and then sometimes there's a jury trial and the jury will decide what the outcome should be. But after that has occurred, then that's where we come into play. So after a case is finally decided at the trial court level, then the losing party has a statutory right to appeal his or her case to our court, to the Court of Appeals. And this isn't a complete do-over of what happens at the trial court level. So, you know, we don't have a new trial. There isn't a jury. We don't call witnesses. Instead, we parse over the written record. So we look at every document that was filed in the case, and we look at every exhibit that was filed, and we look at through transcripts of all of the hearings that occurred. And then the parties or their attorneys will submit lengthy written arguments as to why either the particular result came out correctly in light of the law, or why it should be changed. And then once we've reviewed all of those things, then we hold what is called an oral argument, where the attorneys for each side come in, and it's basically just a conversation with the judges. So we have a conversation over the course of usually 30 minutes where we talk about particular aspects of the case. Maybe we have factual questions, or maybe we're trying to figure out how a particular law, whether you're talking about a constitutional provision or a statute or a case from another court, would influence the outcome. And then once we have done that, I sit on a panel with 3 judges, and the 3 of us will sit down and talk through every aspect of the case. And once we have had that discussion, then we decide, in light of the law and applying it to the facts, how should this case be decided. And then once that's done, we write a written opinion, just like you probably have seen opinions from the United States Supreme Court. It is a difference in degree, but it's the same kind of thing that we do day in, day out.
So Judge, who has access to this process, and has the pandemic affected the availability and the access to folks getting to the appeals process?
Yeah, access is an interesting question, and it's something that we talk about often on our court. You know, appeals are in many ways strange creatures, because you have this whole process that occurs on the back end of a case. And a lot of times the parties who are involved in the case at the trial court level often go to court, they see the judge, they see how a case is kind of moving along. But at the appellate level, that's not necessarily the case, because we review a written record. We don't have parties who appear in front of us. And really the only in-person contact that we have is with the attorneys during that oral argument that I mentioned a few minutes ago. So in some ways, that particular process has lent itself well to a transition during this pandemic. I mean, at the trial court level, there have had to been lots of changes that occurred, because you can't have an in-person jury trial right now, for example. But at the appellate level, if we're reviewing a written record, we can do that. Most of those records are electronic at this point. So even if I'm working in my home office, then I can do that here, right? I don't have to be in Topeka, where the judicial center is and where my office generally is. But we had to figure out how we would do oral arguments, right? Because generally, oral arguments, you're in a courtroom and the attorneys come from all over the state to spend this 30 minutes talking about the case with the judge. And so what we have done is that since July, we have had a full oral argument docket every month, and it's all been on Zoom. And that Zoom oral argument has been live streamed to YouTube. And in a way, it's been fantastic because it allows the public and a window into what we do. Now, all of these arguments are open to the public, but who's going to drive to Topeka and sit through them? But now, anytime you're interested, you can either tune in while we're arguing live, or you can go and you can see the archived argument online. And then the other thing that it does is that it really reduces the cost, so that if you've got someone out in Western Kansas, that party doesn't have to pay for his or her attorney to drive to Topeka and spend all that time just for 30 minutes on a case. Instead, it makes, I think, the courts much more accessible. And so I'm excited about it. I'm excited about the way that we've transitioned, and I think that this is going to really affect the way that we do business basically from here on out.
We've just been through an election season that ended for some a few weeks ago, and we're in the process of that now, and at the national and state and local levels. Your name was on the ballot for retention here in Kansas. Would you tell us a little bit about the relationship between a judicial appointment and a retention election?
Yeah, first I will say that it is surreal seeing your name on a ballot. That's something that doesn't happen in the federal system, even though in a lot of ways the federal system mirrors virtually every aspect of our state court system. And it was nerve-wracking to think of, over 1 million people who I've never met out there trying to decide whether I should remain in this position that I have worked so hard toward. But in Kansas, at least, all Kansas appellate judges and justices, so the 14 judges on the Kansas Court of Appeals and then the 7 Kansas Supreme Court justices are all subject to retention. That means that once we're appointed, and that appointment process differs from court to court, but once we are appointed, then the people of Kansas decide through a general election, through a yes-no vote, whether we remain in that position for an additional term. And I'll say that this is something that I didn't really understand before I went on the court. It is an interesting process, but it's also amazingly humbling. I've voted in person this year, and it was so humbling to look around and know that all of those people who were at the polling place where I was were weighing in on my work. And I think it just drives home that what we do really affects people. And it affects people in a practical and a real and a very important way. And so I guess the retention system oriented me to that reality in a way that I didn't really expect, which was neat.
So leaders are people too, like yourselves, whether you're a judge or someone else in public service. You have your own personal beliefs in addition to your professional standards of conduct and your level of public obligation when you exercise the duties of your position. Would you talk about the relationship between a judge's personal beliefs and your official legal opinion as they're written?
Yes, that's an excellent question. And it makes me think of my former boss, who was Chief Justice Robert Davis of the Kansas Supreme Court. And he used to talk to me about what he called the human face of the law. And that is, when we think of justice and fairness, we usually think of them as these out there ideals. But when it comes down to it, our justice and our system of justice is composed of human faces. And so that means that the parties who seek our review on a day-to-day level are just people, and they're trying to live their lives, and they're trying to figure out how to sort out these very real disputes. You know, the lawyers are human, and most importantly, to your point, the judges are human. And when you become a judge, you don't give that up. It's our breadth of experience in addition to our knowledge and our understanding, intellectual curiosity that fuel those conference discussions that I was talking about. It makes us, or it renders it possible to make fair decisions. But at the same time, you know, as a judge, as a person, we all have not only experiences, but we have individual opinions. We have individual beliefs. And we can't allow those individual beliefs to influence our decisions. We have to decide the cases that are before us by looking at the law, whatever that law may be, analyzing it, looking at the facts of the particular case, and then applying that law to the facts. And it's just so important, because when people go to the courts, they need to know that the decisions that are being rendered are not based on the whim of some individual judge, right? They're based on a system of laws that allows them to be treated fairly. And I think about this, I think about it when we think about the way people talk about courts generally these days. You know, often when people talk about judges and justices and courts or court decisions, they assume that based on the personal proclivities of a particular judge or justice, they know how the outcome is going to be rendered in a case. And I can tell you that in my year and a half on the Kansas Court of Appeals, that just has not been the case. I sit on a court with 14 judges who, or 11 judges right now, but still, who were appointed by 6 different governors from Kansas. And each of those people, each of my colleagues, have their own personal beliefs and ideals, but that doesn't come into our discussion at all. When we go into a case conference, we are just looking at the facts that are presented there. We're just looking at the law, and it's just a very refreshing, and it's something that I think that the people of Kansas should know. It's a very refreshing, but it's also a very fair process.
Judge, for our last question, is there anything else that you'd like people of Kansas or folks to know about the Court of Appeals, or you personally, or your experience today?
You know, it's just been so neat to talk about this, because it's something that is that I'm so passionate about the law and what we do, and in a lot of ways it's kind of the Wizard of Oz behind the curtain. But I think that what people, you know, what strikes me every day about the court system is that the ingenuity of the founders of our country and our state. You know, we have this system of government where we have 2 of the 3 branches of government that are devoted to the political, right? We have people who are deciding from a 20,000-foot view what the law should be, and then how it should be enforced. But the courts are different. Our 3rd branch of government, when it comes down to it, is a very personal branch where real people go in front of real judges to have us figure out what the outcome is in a dispute that affects your everyday life. And we do that conscientiously. We take it very seriously. And so I just want Kansans to know that we work really hard at maintaining a fair and impartial court system, and something on which Kansans can rely.
Judge, thank you so much for your time. It's been fascinating and so informative, and we really appreciate the opportunity to visit with you. Thanks so much.
Thank you.
And to all of you who have joined us for this installment of Living History, thank you for your time. We hope you enjoyed it and gave you some things to think about. We'll see you again in the new year. Until then, take care.